Hi friends, good morning, and welcome to another interesting topic on an interesting day, being the Independence Day. We wanted to pick up a topic which would certainly resonate with the mood of the nation. So, prohibition of Benami transactions. A lot of noise has been made around Benami assets, and you would definitely be seeing a lot of action in this space. Uh, so and so ex-ministers, or at least the aid of someone has been property has been attached, or assets abroad have been stashed, and whatever. So in 2016, the government thought it's appropriate to bring in a regulation which gives it enough teeth to attach properties seamlessly, and also ensure it instills a sense of fear in the minds of people who intend to even think of hoarding assets under Benami uh, shells. Now, before we move on, I would like to thank Bharti and Meenakshi Jayaraman for their sincere effort in getting this through. And these are the legends which the terms used in this. I think most of it is common. You would be seeing as we move on. The presentation background first would start with the objective of the transaction or the term Benami of the regulation. What are Benami transactions? How the regulation tries to prohibit Benami transactions, and what are the rights of the officers who are engaged in enforcement of Benami properties, and what the government's role is post confiscating a property, and more importantly, what are the penalties for getting into this levy. So, Prohibition of Benami Transactions Act 1988 was the original levy, and Section 281A of the Income Tax Act was repealed by Benami Transactions Prohibitions Act 1988, and now we have the recent version, which was the Benami Transactions Prohibition Amendment Act 2016, which came into effect from 1st of November. So the Act prohibits all types of Benami transactions, gives right to the government to recover property held by Benami, and more importantly, there won't be a compensation for acquiring these properties. Furthermore, there is going to be a penalty for acquiring for holding such assets. Before we get into the operational part of the regulation, let's try and understand what do you mean by the term Benami transaction. So it typically refers to an arrangement or a transaction where the property is transferred to or held by a person, and the consideration for such property is paid by another person. So let's say A holds the property or A acquires a property. However, the consideration for acquiring the property by A was not paid by A, it's paid by, let's say, B. And the property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration. So here the property is held by A for the benefit of B, if not immediately but eventually. This is a classic case of a Benami transaction, and we've seen in the past news reports where drivers have been holding properties, maids have been holding properties, and employees have been holding properties. So this is typically how a Benami transaction works. However, given the practical structure of our society, some exceptions were bound to be provided. If a karta of a HUF is going to hold the property on behalf of the property, where a trustee or any person in a fiduciary position, classic case is a depository, holds the assets on behalf of someone, where the property is held by an individual for the immediate or deferred in the name of his spouse or child or his close relatives, then and the source of earning that income for acquiring the property is also well established. Then, in such circumstances, this would obviously be regarded as an exception case under the Benami transaction, meaning they would be outside the ambit. This apart, whenever a transaction is carried in a fictitious name, or a transaction or an arrangement in respect of a property where the owner is not aware or denies knowledge of such ownership, or the arrangement in respect of a property where the person providing the consideration is not traceable or is fictitious. Classic case, you can look at dime a dozen examples in reality where a company from Isle of Man will be investing, a company from some weird corner in BVI would be investing in another company, and if you trace back there, you will not be able to figure out who the real beneficial owner is. So these have been the basic concerns, and which is why this regulation has been introduced, where if you are not able to identify, forget the fact that someone is a binamidar or whatever, if you are not able to identify someone as the fictitious or as the real owner or the provider of funds, then in such circumstances automatically this gets covered under the ambit of Benami transaction. And when we use the word property, it literally encompasses all asset classes. Here we can make a good reference to subsection 14 of Income Tax Act, which defines the term capital asset, where it says property of any kind is a capital asset. Similarly, when it comes to property here, it means assets of any kind, whether movable or immovable, tangible or intangible, corporeal or non-corporeal, and includes right or interest in or legal documents or instruments evidencing the title to or interest in the property, and where the property is capable of conversion into some other form than the property in the converted form, and also includes the proceeds from the property. So literally they're talking about present, past, and future properties of future forms of properties. Now, what happens when someone gets into a Benami transaction? That's the meat of the transaction. We have seen what is a Benami transaction and what happens when someone gets into a Benami transaction. The law says no one shall enter into a Benami transaction. That's a fundamental position. However, post the amendment in 2016, earlier, before the commencement of the Amendment Act, it is punishable with an imprisonment for a term of up to 3 years or a fine or both. But post amendment, it is punishable with an imprisonment of, it's actually rigorous imprisonment of a term from 1 to 7 years, and the fine shall be 25% of the fair market value of the property. And also, please understand, friends, this is in excess over and above the fact that the property will be confiscated by the regulator. No suit, claim, or action to enforce any right in respect of any property held Benami, or any defense on such right action against the person in whose name the property is held, or against any other person, shall lie on or behalf of the person claiming to be the real owner. So literally you have no right over a property which has been established to be a Benami property. And however, in the case of certain charitable institutions, the central government has a right to specifically provide exemptions. And once a property is deemed to be a Benami property, the Benamidar, that is a person who's owning it on behalf of someone, shall retransfer the property back to the person concerned. Benamidar is typically the fictitious person or the namesake, or the name provider who lends his name to own the property. No person being a Benamidar shall retransfer the Benami held by him to the beneficial owner or any other person acting on this behalf. Where he does so, where he tries to retransfer the property to evade this regulation, such transfer shall be deemed to be null and void. Friends, these are the authorities as far as the Benami law is concerned. We have the initiating officer, we have the approving officer, then we have the adjudicating authority, and the administrator for the assets confiscated. And they have the powers of a civil code of civil procedure 1908, pertaining to discovery and inspection, enforcing attendance, compelling the production of books, issuing summons, and receiving evidence and affidavits. Very similar to what happens when a search scrutiny happens in the income tax. And what they've also done is they made it mandatory for officers under other regulations to compulsorily cooperate with officers under the Benami Act. So income tax, these officers are governed by income tax authorities, Customs and Excise, Narcotics, Stock Exchange, and SEBI, RBI, Police, ED, any other body corporate constituted or established under central or state act, other officers of central government or state government or local authorities or banking companies, as the case may be. Literally every regulator or financial institution has to cooperate whenever a Benami regulation inspection is currently being carried out. Next, power to call for information, the initiating authority or the approving authority or the adjudicating authority, as the case. So we have only three. So the initiating or the approving authority, you can look at him as the assessing officer or commissioner under Income Tax Act. Adjudicating authority could be typically a chief commissioner, someone who passes the order. Administrator is someone who manages a property post confiscation. That's how you look at the whole scenario. So shall have the power to require the officer of central government or state government or local body or any person who is responsible for registering and maintaining books of accounts or other documents pertaining to any transaction, and any other person to furnish. So apart from those connected, any other person whom he deems to be connected to the property will also fall within his ambit to be inquired upon. And notice an attachment of property involved where the IO has reason to believe that any person is a binamidar. If you again look at it, friends, the language is very similar to Section 148 under Income Tax Act, where the assessing officer has reason to believe, where we talk about income escaping assessment. He may, after recording his reasons in writing, issue a notice to the person to show cause within the prescribed time as to why the property should not be treated as a Benami property. And a copy of the notice shall also be issued to the beneficial identity. Now, again, a beneficial owner only if the identity is known. It is not mandatory for the income tax for the Benami regulators to show that such and such person is a beneficial owner. Their scope of for confiscation uh, stops as long as they are able to establish that the person who's holding the asset is holding in the capacity of a Benami. Where the IO is of the opinion that the person in possession may alienate the property, then he can do what is called as a provisional attachment of the property. Now, the IO has a period of 90 days from the date of issue of notice to conduct his investigation, and where a provisional attachment is already made, either he can confirm the attachment or release the property. Where a provisional attachment has not been made, then in such cases he might either pass an order for attachment or decide not to attach the property, assuming the person concerned is a genuine owner. The IO shall, within 15 days from the date of attachment, draw up a statement in case it is referred to an as a adjudicating authority. Now, an adjudicating authority technically could be deemed as a quasi judicial officer. The notice may be served as per Code of Civil Procedure if for an individual, for a firm, the managing partner, HO of the Karta company, the principal officer, AOP or BOI to the principal officer, any other person to the person who controls or manages the affairs of the enterprise or the entity. Adjudication. On receipt of statement of the IO, the adjudicating authority shall issue a notice within a period of 30 days to furnish such documents or evidence as is considered necessary on a date to be specified therein, and on the following persons. So the Binamidar, the beneficial owner, any interested party, if there is a loan taken against the property, let's say a banking company, or any person who has made a claim from the property, and the order of the adjudicating authority should be passed within 12 months, within 1 year. Confiscation and vesting of the Benami property. So, where an order is passed by the adjudicating authority in respect of a property holding, he shall give an opportunity of being heard. An appeal can be filed against the order. Where an appeal has been filed, the confiscation of the property shall be made subject to the order passed by the appellate tribunal. So, we have a very similar mechanism what you have under any fiscal levy. And where an order of confiscation has been made, all rights and title in such property shall vest with the central government, free from any encumbrance, as the case may be. So, the moment a Benami property is attached by the central government, all existing encumbrances shall lapse, and it shall be in the custody of central government, completely free of any encumbrance. Any right of third party created in such property with a view to defeat the purposes of this act shall be null and void. Confiscation shall not apply to a property held or acquired by a person from the Binamidar for adequate consideration prior to the issue of notice without having. So, this is again very similar to your Sale of Goods Act, where a transaction is done in good faith, and where someone has acquired the property from the Binamidar for adequate consideration. Then, in such cases, the order of confiscation of the property may not hold good. Now, the CG will establish an appellate tribunal to hear the orders of to hear appeals against the order of the adjudicating authority. Management of property. So this is the final leg of the regulation. The administrator shall have the power to receive and manage the properties. He shall take possession of the property. Then he may notify, as the central government may notify as it may deem fit to perform the administrator's function. The role of the administrator could be to either dispose the property or allocate the property or maintain the property as the case may be based on the decisions and circumstances. The administrator, within 7 days of the date of service of the notice to any person who may be in possession of the Benami property, requires such person to surrender or deliver possession. Where taking over immediate possession is warranted, the administrator may forcibly enforce his right to acquire the property. So penalties, where any person enters into a Benami transaction, it's a rigorous imprisonment of 1 to 7 years, with a fine which may extend to 25% of the fair market value of the property. And where for furnishing false information, it's again rigorous imprisonment between 6 months to 5 years, and a fine of 10% of the fair market value. Any offense under this act cannot be compounded, so you cannot go for a monetary compensation in lieu of arrest. So this is a recent guideline which came in 2 months back, and the government initiative as far as promoting people to come and disclose their knowledge about Benami transactions is anyone who has credible information about a Benami transaction has a right to uh, claim a reward of up to 1 crore. When we say credible, it must be verifiable details of the Benami property. The name and address of the person in whose name the property has been acquired should be very clearly established, and credible basis, including supporting evidence for the information that the property was actually a Benami property, needs to be provided for. If this information is provided for automatically, he shall be eligible for a compensation up to 1 crore. So the regulator says up to 1 crore. The actual number might vary based on the effective collection by the government. Next, when we move to the precedents in this, as far as this regulation is concerned, merely because financial assistance has been provided by father to son, it cannot be viewed as a Benami transaction. And the regulator has the onus to prove that the property is a Benami property. They need not show that the person, the identity of the real beneficial owner, but as long as they are able to prove that the person holding the assets do not have this means or the source for actually acquiring the asset, and that he is a front for someone else, that is adequate compliance as far as this regulation is concerned. Where the applicant company returned an amount received from a company towards supply of ceramic tiles, on finding out the said company was not genuine and it was involved in money laundering, the applicant could not be held to be a beneficial owner of the amount in question. Primarily because just because a party with whom you've had a transaction uh, is a fictitious or a nefarious, was involved in a nefarious activity, it doesn't mean that the person who, in genuine and good faith, has entered into the transaction would be deemed to be guilty under this regulation. So these were some of the recent decisions, friends, which we thought shall be of relevance at this moment. So with this, we wind up our discussion on this topic. Some of our thoughts as far as this top fairly hot topic has been shared with. You always feel free to write to us, and